Sardar Patel College of Engineering. Our institute was established in 1962. It is now an autonomous institution and permanently affiliated to University of Mumbai. It is one of the most sought out institutions for the admissions by the students. Our institute offers BTech, MTech and PhD programs in civil engineering, mechanical engineering and electrical engineering. Now, with reference to our program, let me give you a brief idea. We are blessed by our patrons, Dr. Shesha Iyer, Chairman of BOG SPC Mumbai, Dr. M.M. Murdi, Principal SPC Mumbai, Dr. Reji Mathai, Chairman of SA India Western Section, Dr. Ravikant Pardeshi, President of HSM and Sant Gadgil College of Engineering and Technology, Bhusaval, Dr. Rahul Barjibe, Principal of the same institute, and Mr. Ramesh Pasrija, Executive Director, SA India Western Section. I received a very good support from FDP Coordinator, Dr. Dinesh Patil, and FDP Co-Coordinator, Dr. Shrikant Chaudhary from Sant Gadgil College of Engineering and Technology, Bhusaval. I also received a very good kind of a support by the organizing committee members, Dr. Kiran Bhore, Dean R&D SPC Mumbai, Dr. Girish Kulkarni, IQAC Coordinator and Head in Gadgil College of Engineering and Technology, Bhusaval, Ms. Supriya Rai, Assistant Director at FELA, and Mr. Sagar Murukar at SA India Western Section. I'm proud to say that III SPC Student Chapter has conducted more than 25 mega level events, and we have received a very good support system from our very active team, student team. Right now the active team is Sadhvi Chaube, Chairman, III SPC Student Chapter, Kaip Badshah, Vice Chairman of the III SPC Student Chapter, and Ritesh Borse is also Vice Chairman of the same. Let me give you a brief idea with reference to the program outline. This entire program has been chalked out, taking into consideration the innovation, research, and intellectual property, these three domains. So our first session, it is Introduction to IPR and Patent Filing Practice. Speaker is Dr. Ujjawala Haldankar, former Assistant Controller of Patents, Patent Office, Government of India. Right now, she is the CEO of Intellect Dossier LLP. Second session, it is a keynote speech given on Institution Innovation Council Guidelines, Framework and Path Ahead. For this purpose, we have the eminent speaker, Mr. Surender Rao. Surender, he is from Western Regional Office as a Zonal Coordinator for IIC Implementation Team, Ministry of Education, Innovation Cell, AICTE, New Delhi. Our third session is on patent specification drafting, part 1. Similarly, we have the part 2 session as a fourth one. Our fifth session is trademark and domain name issues given by Mr. Vikas Asavar. Then sixth session, optimization and further streamlining of IPR registration and granting power of controllers. We have the eminent speaker, Dr. S.S. Singh, former Senior Joint Controller, Patent Office, Delhi. Copyright insight and related strategic issues will be the seventh session offered by Shri Raghavendra GR, Joint Secretary, Department of Justice, Ministry of Law and Justice, Government of India. Our eighth session is Innovation and IPR Strategy for Institute and Industry, Dr. Saigal, Managing Partner at Saigal IPR Services. Session 9, Research Paper Writing and Publication, conducted by me. And the last session, Innovation and Incubation Theories and the Best Practices, by Dr. Kiran Talele, Dean Student Affairs, SPIT Mumbai. I welcome all the participants to this session. I wish them happy learning. Thanks to all of you.
Thank you, sir. Thank you for your kind words and such a warm welcome to all the participants and also introducing the event to everyone. Further, now I would like to request Dr. Dinesh Patil sir, coordinator and head of Computer Science Engineering Department of Sri Sant Gadge Baba College of Engineering and Technology, to kindly speak a few words. Hello, Dr. Dinesh Patil sir.
Hello.
Yes, sir.
Sir, I am audible now?
Yes, sir.
Yeah. I am Dr. Dinesh D. Patil, FDP Coordinator and Head of Department of Computer Science and Engineering at Sri Sant Gadge College of Engineering and Technology, Bhusawal. I am thrilled to welcome you all to our jointly organized one-week faculty development program on innovation research and IPR journey towards excellence. I feel honored to be a part of this program, which has been meticulously designed to provide an immersive and enriching experience to all the participants. Our objective is to provide for the exchange of ideas, knowledge, and best practices related to innovation, research, and intellectual property rights. I would like to express my gratitude to our collaborative institution, Bharati Vidya Bhavan, Sardar Patel College of Engineering, for their supports and collaboration in our organization for this program. I would like to extend my sincere thanks to our chief guest, Dr. Reji Methai, Chairman, Society of Automotive Engineers, India Western Region section, for this FDP, whose distinguished experience and expertise have made him a prominent figure in the field of engineering and technology. Your presence is highly appreciated and we are honored to have you with us. I would also like to extend a warm welcome Mr. Ramesh Pasrija, Executive Director, Society of Automotive Engineers, India Western Section. Dr. M.M. Muradi, Principal of Sardar Patel College of Engineering, Mumbai. Respected Professor Dr. Rahul Varjive, Principal of Sri Sant Gadge College of Engineering and Technology, Bhusawal. Dr. Santosh Rane, Sir, Convener of FDP, Faculty and former Dean Academic, Sardar Patel College of Engineering, Mumbai. Dr. Girish Kulkarni, IPAC Coordinator and Institute Innovation Council Convener of Sri Sant Gadge College of Engineering and Technology, Bhusawal. Dr. Kiran Bole, Dean R&D, Sardar Patel College of Engineering, Mumbai. And the guest speakers, Mr. Surender Ramurthy, Dr. Ujjawala Haldankar, Mr. Tapan Brahma, Dr. S.S. Singh, Dr. Raghvendra, Dr. C.K. Sehgal, Dr. Kiran Tarale, and all the faculties and participants. Your active participation and engagement are crucial to the success of this program. I am grateful for the opportunity to be a part of this program, and I hope that it will provide all of us with a valuable learning experience that can help us and excel in our professional endeavors. Thank you all for joining us, and I wish you all a successful and rewarding week ahead. Thank you.
Thank you so much, sir. Thank you so much, sir, for your kind words. Further, now I request Professor Dr. Rahul Varjive, sir, Principal, Sri Sant Gadge Baba College of Engineering and Technology, to kindly address the participants.
I am audible to everyone?
Yes, sir.
Yes. Honorable dignitaries present in the online gathering. Dr. Reji Methai, Chairman, Society of Automotive India, Western Section, India. Mr. Ramesh Pasrija, Executive Director, Society of Automotive India, Western Section, India. Ms. Supriya Rai, Assistant Director, Federation of FILA, New Delhi. Dr. M.M. Murdi, Principal, Sardar Patel College of Engineering, Mumbai. Dr. Kiran Bole, Dean R&D, Sardar Patel College of Engineering, Mumbai. Dr. Santosh Rane, Convener of this FDP and former Dean Academics of Sardar Patel College of Engineering, Mumbai. Dr. Dinesh Patil, Coordinator and Head of the Department of Sri Sant Gadge Baba College of Engineering and Technology, Bhusawal. all the distinguished resource persons who are associated with this FDP, and all my dear enthusiastic participants. Namaste and good afternoon to all. It gives me an immense pleasure to interact with all of you in this pleasant and bright afternoon from Bhusawal. I, Dr. Rahul Barjibe, Principal of Sri Sant Gadge Baba College of Engineering and Technology, Bhusawal, welcome you all to this national level FDP program. The response received to this FDP is really overwhelming. From all states of the country, with more than 1100 plus registration has received. Our vision is to impart the quality education and achieve the excellence through education, as a result of which our many students are working in many MNCs as global leaders. In this national level FDP program on innovation research and IPR, journey towards excellence, I expect that it will be fruitful to all people of the society who will gain insights on the topic of the research, innovation, and intellectual property rights. The three key things this FDP will cover: first one, innovation, which is the practical implementation of the ideas that result in the introduction of the new goods and services. Second, research, that is creative and systematic work undertaken to increase the stock knowledge. And third one is the intellectual property rights, referred to the legal rights given to the inventor or the creator to protect his invention or creation for the certain period of time. As a faculty participating in this FDP, the biggest takeaway will be how a problem statement can be solved in innovative way, and at the same time, the rights of it are sustained so that it can be fruitful in future. In this world where today data information is more expensive, then let us know how to increase the intellectual property. I give my best wishes to all the participants to gain maximum knowledge through this platform of FDP. Thank you everyone. Jai Hind, Jai Bharat.
Thank you so much, sir. Thank you so much for your kind words. Now I request Dr. M.M. Murthy, sir, Principal, Sardar Patel College of Engineering, Mumbai, to kindly address the participants.
Sadhvi, please go ahead.
Yes, sir.
Sadhvi, please. Yeah.
Okay. Sir, Murthy sir is not present.
He's not there.
Okay, sure.
He's busy with some other things.
All right, sir. No issues. Now I request Dr. Kiran Bhode, sir, Dean R&D, Sardar Patel College of Engineering, Mumbai, to kindly speak a few words.
Sadhvi, please check whether Kiran Bhode sir is also there.
Sure, sir. I'll check.
Because I don't find him.
Yes, sir. I can also not find him. I'll go ahead. Now I would like to request Ms. Supriya Rai, Assistant Director, FELA, New Delhi, to kindly address the participants.
No, Supriya is also not there.
Now I request Mr. Ramesh Pasirja, sir, Executive Director, SA India Western Section, to kindly speak a few words.
Sadhvi, am I audible?
Yes, sir. Yes. Yes.
Thank
you
you.
are
Thank you.
Yes, sir.
So it is my pleasure to be part of this inauguration program of FDP on innovation, research, and IPR journey towards excellence. My compliments to Dr. Shesha Iyer, Dr. M.M. Murudi, Dr. Reji Mathai, Dr. Ravikant Pardeshi, Dr. Rahul Barjibe, Dr. Santosh Rane, Dr. Dinesh Patil, Dr. Shrikant Chaudhary, Dr. Kiran Bhode, all organizing committee members, all speakers and participants. You are going to have a wonderful journey through this faculty development program. This is very, very important for us in India because innovation keeps important for keeping the economy of the country ahead. Our products need to be ahead of others, and we cannot be in the me too mode, means we also do that, we also do that. We should be the first ones to come out with something new in the products, and whatever new we come up, that needs to be protected, and IPR is an excellent important tool for that. So I'm sure all of us are going to benefit a lot in this. My best wishes to the organizers, speakers, and participants. All the best. Thank you very much.
Thank you so much for your kind words, sir. Now I request Dr. Reji Mathai, sir, Chairman, SA India Western Section India, to kindly speak a few words.
Sadhvi is not there.
All right. Now I request Dr. Shrikant Chaudhary, sir, co-coordinator of this faculty development program, to kindly speak a few words and also introduce us to the eminent speaker of the session, Dr. Ujjawala Haldankar.
Thank you, Sadhvi. Good afternoon to one and all present here. On behalf of Bharati Vidya Bhavan, Sardar Patel College of Engineering, Mumbai, and Hindi Seva Mandal, Sri Sant Gadgil College of Engineering and Technology, Bhusawal, I, Dr. Shrikant Chaudhary, co-coordinator of 5 days National Level Faculty Development Program on Innovation, Research, and IPR Journey toward Excellence, welcomes respected chief guests, honorable principals, head of departments, eminent guest speakers, faculties, and participants. Now, let's start our FDP's first session by introducing our speaker. I heartily welcome today's eminent speaker. Ma'am, it's a great pleasure for me to introduce you for this session. Dr. Ujjawala Girish Haldankar ma'am is our first speaker for today's session. She completed her BSc and MSc in microbiology from University of Mumbai. She completed her LLB from University of Mumbai and PhD in biotechnological methods from University of Mumbai. Currently, she is an CEO at IPR Dossier LLP Limited Liability Partnership Firm from November 2022. She worked as a head of office at Senior Patent Attorney at IPR firm Deepening, Mumbai since May 2019 to October 2022. She also worked as Assistant Controller of Patent and Design, Gazetted Officer Class 1, Patent Office, Government of India, Mumbai since January 2005 to March 2019. She also worked as R&D Manager, Cell Culture Division with High Media Labs Private Limited, Mumbai since September 2004 to January 2005. She was a postdoctoral fellow on a project involvement of cytoskeletal proteins in retroviral assembly in the Public Health Research Institute, New Jersey, USA since May 2003 to April 2004. She also worked as a senior research fellow on CSIR, Council of Scientific and Industrial Research project in Cancer Research Institute, Tata Memorial Center, Mumbai since July 2002 to February 2003. She is a microbiologist with Cipla Limited, Mumbai since March 1997 to July 1998. She is a registered patent agent in India. She holds many responsibilities like providing strategic advice to clients in regard to IPR in field of pharmaceuticals, chemicals, biotechnology, life sciences, mechanical engineering. Leading team of patent attorneys and trademark attorneys, interacting with Europe, United States, and other foreign associates for prosecution of patent application and maintaining patent portfolio of clients. She had been in charge of different section of patent office at RECS, receipt, EDP, classification and screening section, document receiving and processing till examination of patent application, RMID, renewal and maintenance of granted patents, assignment and licensing registration, and RTI and administration and establishment. We are incredibly fortunate to have such a wonderful and dynamic personality with us for this session. We are overjoyed, ma'am, to hear you as a resource person for this 5 days online faculty development program. Now, I request you, ma'am, to enlighten us on the subject Introduction to IPR and Patent Filing Practice. Now, I would like to invite Dr. Ujjawala Haldankar, ma'am, to start the session and address our participants. Over to you, ma'am.
Thank you, Dr. Chaudhary. Firstly, I'm audible, right? Hello?
Yes, you are audible, ma'am.
Yeah. So firstly, I'd like to thank Dr. Chaudhary and Dr. Rani and other organizing team for inviting me for this lecture. I'm sharing my screen.
Yes. Hello.
Yes, I'm sharing.
Yeah. Please share.
Yeah.
Visible, ma'am?
Yeah, okay. So my topic is Introduction to IPR and Patent Filing Practices. Intellectual property rights. Firstly, what intellectual property means? Intellectual property refers to the creation of mind, creation by a person. It can be invention, it can be some literary work, it can be artistic work, it can be designs, symbols, software. Any creator will definitely will like to have rights over it, or will like to have his ownership over it. So these are the creations originated from the intellect of a person, and the person must be awarded with some recognition for his creation. The authority governing that particular territory grants certain rights to the creator of intellectual property, and those are intellectual property rights. So intellectual property rights refers to the legal rights given to the inventor or creator to protect his invention or creation for a certain period of time. These legal rights confer an exclusive right to the inventor, creator, or his assignee to fully utilize his invention or creation for a given period of time. So it is exclusive right, it excludes others to use his invention without his consent, and these rights are for limited period. Intellectual property rights, for now we all know that India is being recognized by foreign countries as source of manpower. It is kind of cheap manpower in India. That is why they try to establish their production units in India. We should be recognized as on the basis of the knowledge or on the basis of the creation, and not just as a cheap manpower. So intellectual property rights need to be an agenda for economic development of India. Indian economy should be a knowledge-based economy. India's international competitiveness should be based on the knowledge rather than on the cheap labor and availability of raw material. Legal and administrative regime of IPR bestows confidence to the IP owner and builds his capacities to create the crucial link between research and its economic applications. So if the inventor is sure that his invention will get protected and he will be getting benefited out of his invention, he is encouraged to further develop more inventions. And that is why legal and administrative framework to protect the inventions or to protect the creations is must, and it should be properly enforced. Two major elements of intellectual property system. First is registration of the IPR, and second one is recognition of IPR. So registration of IPR, whoever creates IPR should think of registering it. It shouldn't be like I have created, I have published, that's it. If you register, then only you will have rights over it. If you publish, you don't have rights over it. It is into the public domain. Your invention will be in the public domain. You can't claim any right over it. It is free for everyone to use. Registration of IPR, the approach should be to create IP rights by registering patents, designs, trademark, copyright, geographical indications. Recognition of one's right. This is very, very important aspect. If anybody creates intellectual property, we should have respect for it. We shouldn't say, okay, now he has done work, okay, it is easy for me to copy what he has done. Ready invention is very easy to copy, but to create invention takes some effort, some intellect. So we should respect that intellect, and we shouldn't be copying or emitting anybody's invention or creation. Recognition of one's right for registered IP. When one comes across the registered IP rights of an individual or legal entity, the IP right should be respected and should not be infringed by imitating or copying. Types of intellectual property rights: patent, designs, trademarks, geographical indications, and copyright. We'll start with trademark first. Trademarks are the marks that create some recognition of the product in the minds of the user. By seeing trademark, we recollect the product related to that mark. So trademarks are the most widely used intellectual property form in commerce. we see many trademarks all around us. Branding creates distinct identity for a business in the minds of the consumers. Branding and trademarks, these are keys to commercial success. Branding is the process by which the name or the identity of a company, an enterprise, an organization is communicated. Branding allows a company to differentiate its products and services from the competitors by creating a bond with its customers. So once brand is created, we immediately Sony, Samsung, Whirlpool, these are the brands, and we trust these brands. We say, oh, it's from Sony, it must be good. It's from Whirlpool, yes, you can buy it. So the brands communicate quality. Brands communicate reputation. That is why creation of the brand is very, very important for commercial success of the product. Trademark is an intellectual property that is depicted as a visual symbol, label, sign, or design in order to represent a product by a manufacturer. It helps customers to distinguish the products or services of one company from the rest. The owner of a trademark can be individual. Any individual can apply for the trademark. It can be company, it can be a partnership firm or group of people. Trademark is of significance in identifying the origin and source in respect to the quality of a product, ensures uniform standards in quality. By just name, we feel very comfortable or confident about the quality of the product. Effectively provides advertisement to the products and builds a goodwill and image for the product. Trademark legislation in India. Trademark is administered through Trademarks Act 1999 and Trademark Rules 2017. So these are some known trademarks to us which we come across in our day-to-day life. Reliance, Mahindra, Asian Paints, Tata, Haldiram. So seeing this trademark, we immediately recall the value of the product. Types of trademark. It can be product trademark, mark used on the product. Service mark, mark used for services being provided. Collective mark. Collective mark is a mark used by a group of people. Say pharmacy or medical shops, they use green cross. So that is collective mark. A group of people or a particular group of people which are into particular business are using this mark. So it's a collective mark. Informs the public about certain distinguished features of a product or service representing a collective use. Certification mark. It's mark like ISO standards. We have ISO standard mark on the products or FSSAI mark on food products. So these are the certification marks, or the chartered accountants use mark on their documents or on their letterhead. So these are certification marks. A sign that denotes a product's origin, material, quality, or other specific details which are issued by the proprietor. Shape mark. Shape of the label, shape of the article also can be trademarked. Pattern mark. Products that have specific design patterns that come out as a distinguishing factor of the product. So pattern mark can also be trademarked. Sound mark. Sound mark is associated with the product or service originating from certain supplier. The best known sound mark to us is IPL tune. We immediately recollect, when we hear that tune, we immediately recollect IPL. So regarding sound mark, one company, a very well-known company in India, they prepared one video for launching their new car. And they launched that video on YouTube. It was some 7 to 8 minutes video. And in that video, there was 28 seconds of some music played for 28 seconds. So that music, a firm from New York filed the, or rather sent them notice that we will file suit against you if you don't delete that tune from your video. And now for that 28 seconds of music, this negotiations are going on, and the company has to pay some $1,000 to the New York-based company. So this is the value of the trademark. The validity of the trademark is for 10 years and it can be renewed further by 10 years by paying renewal fees. Cancellation of trademark. Trademark can be cancelled by on request of the third person. Hello? Hello? Yeah, so trademark can be cancelled on request of the third person if the trademark hasn't been used for 5 years and anybody files request for cancellation of the trademark. Trademark is liable to be cancelled by the trademark registry, and then this trademark is free for use by anybody. Infringement of trademark. If somebody is using registered trademark on his product without the consent of the owner of the trademark, then the owner of the trademark can file infringement suit for infringement of his trademark. Now we'll get some introduction for designs. Designs is protection for visual appearance of a product. Designs, the industrial design recognizes the creation, new and original features for new shape, configuration, surface, pattern, ornamentations, and composition of lines or colors applied to articles, which in the finished state appeal to and are judged solely by the eye. Design system focuses on the aesthetic features derived from visual appearance of an article. So design protects just the visual appearance of the article. Design will not protect the use of the article. Design will not protect function of the article or process of manufacture, any other aspect, no other aspect than the visual appearance. Design applications are generally filed as photographs or as engineering drawings, photographs of the product itself. Design legislation in India, Designs Act 2000, the Design Rules 2001. Actually, this Design Idea Act, these acts were enacted in India because of the liability under TRIPS agreement. So, essentials of design. Design, for registration of design, it has to be novel. It shouldn't be in the public domain, it shouldn't be known by the public. So, has not been disclosed to the public anywhere prior to the date of filing, a priority date, is significantly distinguishable from known designs or combinations thereof, does not comprise or contain scandalous or obscene matter. Term of protection, it is 10 years and can be further extended by 5 years. These are some of the registered designs. So this is first one is the bottle cap. Second one is a sheet manufacturing machine. Third is camera, as you can see, and the fourth is car, vehicle. So from small cap to car, anything, maybe designs for the clothing, jewelry designing, anything can be protected by design registration. Refusal of design can be challenged in High Court. If the design application filed in the patent office is refused by the controller, then for his order, appeal can be filed in the High Court. Cancellation request for registered design can be filed in patent office. If anybody finds that design has been registered, however, that design was available in the public domain before the filing date, then that person can file cancellation request before patent office, saying that this is not a novel design, this is already known to the public. So on receiving this cancellation request, controller will examine the case and conduct hearing and will decide whether to keep the registration of a design or whether to refuse the design. Infringement suit can be filed in the High Court. If somebody is using registered design without the consent of the owner of the design, then the owner of the design can sue the infringer and thus claim for the damages. Copyright. Copyright, as we all know, it is for the literary work, for the performances, for the for we can say for broadcasting. So in the media, social media, copyright is very important. Copyright is an intellectual property right that law gives to a creator of literary, dramatic, musical, and artistic work and a producer of cinematograph films and sound recordings. Legislation for copyright in India, the Copyright Act 1957, the Copyright Rules 2013. Term of copyright: original literary, dramatic, musical, and artistic works. This work enjoy the I think the most lifespan. It is the 60 years in addition to the lifespan of the author. The term of copyright is a kind of I'll say very big term. It's the author's lifespan plus 60 years after the author's demise. And if there are multiple authors, the term is 60 years post the death of the last author. So broadcast reproduction rights. Broadcast reproduction rights are for 25 years. Performance rights, these are for 50 years from the date of performance. Now, geographical indication. This is again very, very important right for India. Geographical indication is very important and significant IP right for India. India has plenty of diverse natural resources. India is an agricultural country and has many different products originating from different regions. That is why geographical indication, that is identity of the territorial origin for the product, becomes very important for India. Geographical indications are intellectual property rights that serve to identify that a product with GI originates from a specific geographical area and has a quality, reputation, or other characteristics that are essentially attributable to its geographical origin. So the product with GI tag is for certain will have characters or repute of the that particular geographical region. It can be attributed to particular geographical region. Geographical indication can be sign or name. A GI or geographical indication is a name or sign given to certain products that relates that product to a specific geographical location or origins like a region, town, or country. Using geographical indications may be regarded as a certification that the particular product is produced as per traditional methods, has certain specific qualities, or has a particular reputation because of its geographical origin. So geographical indication or GI tag is actually the certification that the product with GI tag will have XYZ typical characteristics as this product is originating from particular locality, particular region. So geographical indications are typically used for wine and spirit drinks, foodstuffs, agricultural products, handicrafts, and industrial products. GI tag ensures that none other than those registered as authorized users are allowed to use the popular product name. In order to function as a GI, a sign must identify a product as originating in a given place. Now this authorized users concept. Authorized users, producers from that region, if they want to use GI tag, they have to apply before GI registry that I want to be authorized user for the GI tag. So the registry will scrutinize his application and will grant him certification of authorized users. Only authorized users are allowed to use GI tag on their product. Even if the product is very similar to the product of GI tag and is being produced in the same geographical region, but that producer is not authorized user listed in the GI registry, then he cannot use a GI tag on his products. Benefits of geographical indications: enhance the reputation of the goods, build consumer confidence. It specifies that these goods will have these particular characteristics, and because of the GI tag, consumer feels confident that yes, this product is certified to have these certain characteristics. Communicate their commitment to social responsibility, support regional economic development, prevent fraudulent uses of IP rights. Legislation for geographical indication. The Geographical Indications of Goods Registration and Protection Act 1999, the Geographical Indications of Goods Registration and Protection Rules 2002. In India, first GI registered is Darjeeling tea. Now, filing of GI application. GI application should be filed in GI registry, and it needs to be supported by the affidavit claiming the interest in the production of that certain goods. So the applicant can be the association. Yes, GI application cannot be filed by any individual. GI application has to be filed by association of persons or producers, or some organization or some authority. Individual cannot find GI application because it is collective right. It is not individual right, it is collective right. The applicant can be the association or persons or producers or any organization or authority, and should represent the interest of producers of the concerned goods by filing an affidavit how the applicant claims to represent their interest. Essential documents required with the GI application: affidavit showing interest in producing goods, details of the special characteristics of the product or service and how the standards are maintained, how the standards will be maintained throughout the life of the GI, even that should be documented. Certified copies of the map of the region to which the GI relates, and details of the inspection structure, if any, to regulate the use of GI in the territory to which it relates. So there must be some control who is using GI. So how that will be inspected, that solution or that scheme has to be provided in the GI registry. Registration of geographical indications. Application is filed in GI registry. It is examined by the examiner. If there is any formal deficiency communicated to the applicant, has to be complied within a month. Then the technical examination takes place in consultation with the group of experts. If the experts are satisfied, it is accepted, or otherwise show cause notice is issued, hearing is conducted, and on hearing, if the registrar of GI is satisfied, then the mark is accepted for GI and it is published in the GI journal. Now it is open for opposition for 3 months. It can be extended by another month. Anyone who feels that this GI shouldn't be granted for this territory can file opposition. If no opposition is filed, after 3 months, the GI is registered, certificate is issued, and this GI can be further renewed and can be kept active. A such term of GI is 10 years, and it can be extended further by renewal of the GI by payment of fees. Benefits conferred by geographical indication registration: prevents unauthorized use of GI tag on products by others. So if GI is registered, you can legally sue other person who is using GI tag on his product but not belonging to that particular territory. It helps consumers to get quality products of desired trades and is assured of authenticity. Promotes the economic prosperity of producers of GI tag goods by enhancing their demand in national and international markets. Goods with GI tag are priced minimum double than the same goods which do not have GI tags. So these goods can be, if they have GI tag, can be sold at higher price, and thus the producers in that particular region will be economically benefited. And if there is increase in the demand of the product because of the GI tag, then it leads to job creation in that territory. However, a protected GI does not permit the holder to forbid someone from making a product using the same approaches as those set out in the standards of that indication. So if the product is being produced and those standards has to be disclosed with GI. If using those standards, somebody from outside that territory, outside the territory of that particular GI, is preparing the product and selling in the market without GI tag, it is legally allowed. If he is using GI tag, it is not allowed, but same product can be produced in another territory and can be sold in market, but without GI tag. Role of GI in rural development. Geographical indications are mostly traditional products produced by rural communities over generations that have gained prominence on the markets of their precise qualities. The recognition and protection of the markets of these products encourage the producers' community to maintain the precise qualities of the product on which the reputation is built. Geographical indication products tend to generate premium brand price. As I said, once the product is tagged with GI, its price increases minimum double. In order for a geographical indication to effectively create brand equity for a product or to have a positive effect on rural development or the preservation of traditional knowledge, traditional cultural expressions or biodiversity, it is necessary to develop a comprehensive geographical indication scheme for commercialization of GI tagged products. So only registering GI is not enough. Those goods should be projected in different markets. New markets should be found out for those goods, and advertisements should be done for these goods, and market should be developed so that producers of these goods are commercially benefited. These are few GIs from India. This is Bengurla cashew with territorial jurisdiction of Maharashtra. Vaghya Ghevda, Maharashtra. Then this is Wayanad rice from Kerala. Mysore silk from Karnataka. Pipali art from this is from Odisha, and Kanauj perfume, Uttar Pradesh. So under GI tag, you can register for agricultural products, you can register for manufactured products, or you can register for handicrafted products. This state-wise list of registered GI. Karnataka tops the list. Then is Kerala, Maharashtra, and Uttar Pradesh. Till date, 432 GI have been registered in India, and in Europe, more than 59,000 GI have been registered. Germany is the country which is topping in the registration of GI with more than 15,000 GI. Now, this authorized user applications. As I said, if producer wants to use GI tag, he has to register with the GI registry for using GI tag on his product. So from 2003 to 2009, there were 0 applications for authorized user. Thereafter, awareness started increasing. From 2009 onwards, authorized user applications are being filed. Now total 13,569 applications have been filed for authorized user. Out of that, more than 7,700 applications have been granted. And now India needs to identify more and more GI products and file more and more GI. GI is the integral part of the system for economic development, and it tags as tools to protect the ownership rights on natural resources. This is a tool. GI is a tool to protect our natural resources, our traditions, our goods which are being manufactured by handicraft. Now, for India, it is kind of, if the GI is put to extensive use, I think it will lead to major economic development, because we have several distinct agricultural produces which are kind of characteristic of particular region and particular territory. So if these GI rights are exploited appropriately, definitely it will lead to rural development in India. Now let's go to patents, the topic of interest of everybody, I guess. Patent, everybody knows that patent is for inventions. Patent is an exclusive right granted by the government to the applicant for his disclosed invention of industrial product or process, which should be new, non-obvious, useful, and patentable as per the patentability criteria laid down by the national law. Legislative framework for patent administration. Patents Act 1970 and Patents Rules 2003 is the framework which protects or which administers the grant of patent in India. First patent in India was granted in 1856, and world's first patent has been granted in 1421. So we are kind of far behind the world, and we have to kind of cover long distance to catch up with the European countries. So what is patent? Patent is an exclusive right granted by the government to the applicant for his disclosed invention of industrially applicable product or process. The patent right is granted to applicant of the patent and not to the inventors of the patent. So owner of the patent is the applicant. Who is applicant of the patent will be the owner. All rights for the patent will vest with the applicant and not with the inventor. So if inventors want to retain the rights over the patent, then they have to be included as applicant in the patent application. Now, it's legal protection which gives the patentee the right to exclude others from commercial use of the patented invention in the country of issuance. So it is the right which excludes others from use of the invention. It is exclusive right. If anybody wants to use the patented invention, he has to take consent from the patentee, owner of the patent. Again, patent is a territorial right and is valid only in the country where it is granted. There is no global patent, there is no international patent. Patents have territorial jurisdiction, and if you want your invention to be patented in XYZ country, you have to apply for patent in that country. There is international application, but there is no international patent. We will see what is international application later, but there is no international patent, there is no global patent. It is in each country. You have to apply in each country, and you have to get it granted in that particular country. So it's a sanctioned exclusive right for a set number of years in exchange for disclosure to the public. So this exclusive right is for 20 years. Term of patent is for 20 years. Patent is a grant of exclusive right by the government to the inventor or his assignee for his disclosed invention. Patent rights enables the patentee to take legal action against any person who is exploiting the patented invention without consent or license from the patentee. It is granted for a limited period and can be enforced only in the country where it is granted. So patent, if it is granted in India, it is enforceable in India only, and any other person in some other country, say Japan, is free to copy your invention, is free to sell the products related to your invention, and you cannot take any action against him. So it is territorial right, and it can be worked only in the country of the grant. The patent rights enables the inventor to derive material benefits. The patents can be sold, patents can be licensed, and thus the inventors can be benefited from the patented invention. It's property, it can be sold. Limitations to the patent rights, compulsory licenses. Government is granting its patent with the intention that if the invention is disclosed to the public, there will be further development. Somebody will try to work out some alternative way. If the one invention, one process is kind of blocked by patenting, the other person will try to find out some alternative way, and there will be thus further development which will lead to economic improvement or economic development in the country. This is the intention of the government. The intention is not to create monopoly, or intention is not to give monopoly right. Intention is to give the recognition to the inventor, to give award to the inventor that he has created something which is benefiting the society and which may lead to economic development of the country. So the patent, it is required that patent. Yes, sir. Okay. Okay, fine. Yeah, okay. Yeah, okay. Limitations to patent rights. So we were talking that these rights are not given. I think I'm clearer now. Is my voice clear now?
Yes, ma'am.
Yes, better, madam, better.
Yeah. So we were talking about the monopoly and the intention of the government for giving these patent rights. So patent rights are not given for creating monopoly. Rather, these rights are given for the disclosure of the invention as award to the inventors. And it is intention of the government that the patented invention should be worked in the territory of India. If the patented invention is not worked in the territory of India, somebody can file application for compulsory license. That I will produce this invention and I will commercialize it, so that the invention is put to use and the technology develops further. So there are three conditions on which somebody can apply for compulsory licensing. That is, one is invention is not being worked out in the territory of India. Second, invention is worked out, products are produced. However, the products are exorbitantly charged, which is not affordable to common people of that country. And third condition is product is produced and is being sold in the market of that territory. However, the public demand is not getting satisfied. So if that public demand is not getting satisfied, if this can be proved by the third party, then they can apply for compulsory licenses. Since the enactment of patent law, only one compulsory license has been granted in year 2012. Some of you might be knowing because it is kind of much discussed issue. And the other developed countries which are kind of having dominance in this area were very unhappy and they reacted very harshly on that.
And since then, no compulsory license has been granted in India. There have been some 4-5 further applications for compulsory licenses. However, till now, no other compulsory license has been granted. The compulsory license was granted for Nexavar, Bayer's drug, and Natco Pharma had applied for compulsory licensing. It was Nexavar it was for kidney and liver cancer. The treatment for 1 month was costing 3,200 euros for 1 month, that is 2.5 lakh rupees per month. And Natco came up with the application saying that if we prepare and we are allowed to manufacture this drug and to sell in the market, we will be selling it at the price of rupees 8,000 per month. And compulsory license was granted. However, we will have to think otherwise also, that every time when these companies like Bayer or big companies, Roche, Novartis, whoever are now into innovation rather than production, these companies, when they are working on it, it is not that every now and then they are getting these blockbuster drugs. They put some 10-15 years of research and then they are getting one product which is really commercially viable. They are putting their intellectual efforts, they are putting their physical manpower, they are investing money into it, they are investing their time into it, and some 10 to 15 years of work, phase 1, phase 2, phase 3 trials, clinical trials, and after that they say, yes, this is the drug which is really viable drug and is helpful to the mankind. And after doing all this, if somebody says, hey, what is this? I can manufacture it in such low price. I think there needs to be some balance, because invention is not like coming out in a day or two. It needs financial investment, intellectual efforts, and we have to value all these things. So it's again government policies. A common misperception: patents inhibit free exchange of information. It's not that patents inhibit the exchange of information. Rather, patents are for disclosure of the invention. Patent is granted so that the invention is open in public domain. It is disclosed in public domain. Public knows what the invention is, and there can be further development based on that invention. Otherwise, somebody else will come up with the same invention. So instead of having time and efforts invested in inventing similar products, if this product is disclosed, that yes, this product is now known or this process is now known and I have invented this process. If this disclosure is there in the public, alternative ways can be found out and there will be further development. That is why this patent right is as an award to the inventor for inventing his product or process. And it does not any way inhibit the exchange of information, rather it disseminates the information. Patent law requires disclosure Patent law requires disclosure of the structure of the invention. It is mentioned in the section 10 of the patent law that invention should be fully and particularly described, fully and completely described into the complete specification. Best method of performing the invention should be disclosed in the complete specification. A person who is a skilled person should be able to reproduce the invention with the help of the information disclosed in the complete specification. So, Act mandates that the invention should be completely disclosed in the complete specification. And if you're thinking that, yes, this is kind of critical thing and I shouldn't be disclosing as it will get copied immediately and I will kind of lose it. Whatever you are not disclosing in this specification is not getting protection. Whatever you are disclosing in this specification is protected. So try to disclose as much as possible in this specification. Patent applications are typically published 18 months after filing. Section 11A, and thereafter upon grant, Section 43(2). So patent application, once filed, is published after 18 months. Yes, you can request for early publication. If you file early publication request, it gets published within a month's time. But typically, it is published after 18 months. This this publication prior to examination is notice to the public that this invention has come to us for grant of exclusive right. This is notice to the public so that if anybody has any objection, can communicate to the patent office. Again, once the patent application is granted, it is published in the patent office journal saying that this invention now enjoys legal protection. So this is granted patent and nobody now can use this invention without the patentee's consent. So patent application as such is published 2 times, once after application but before examination, and once when it is granted. An applicant is free to disclose the invention anytime after the application is filed without jeopardizing patentability. Yes, once the patent application is filed, you can disclose the invention to anyone. You may have to commercialize it. You may have to take further trials on it. You may, for technology transfer, you might be talking to some companies. So once you have filed it, you are safe. Then you can disclose your invention to other person. A patent right is not right to perform the invention or monopoly in the marketplace. As I said, it is not monopoly right. It is right to exclude others, but it is not monopoly right. It is right for exclusion of others in regard to the working of patentee's invention. Why invention to be patented? Source of recognition for the inventors. If inventors get recognition that this invention has been created by me and I have been named as inventor in this patent application, so it is some recognition, it is encouragement to the inventors. So patent is considered as source of recognition. Incentive to develop a commercial product. It gives incentive for development of the commercial product. If the product can be marketed, then yes, invention is successful. That is why it is said that if your patent or patented product finds proper place in the market, then you get good incentive for that patent. License to an existing company, startup, protection against imitators. Yes, without patentee's consent, nobody can use his invention once granted, and if anybody is using, infringement suit can be filed. While dealing with patent filing, don't publish before you file. We scientific community are generally kind of having tendency to publish the whatever research or whatever findings we have. We try to publish it as early as possible. So please don't do that. If you have any good invention which you feel has a marketable value, which you feel has commercial value, which has some applications, please don't publish it. First file, go for patent application, and then only you publish it. You can then next day file your patent application today. Tomorrow onwards you start your publication process. So first file patent application, then only go for any kind of disclosure. File provisional application if not ready with complete specification. If you feel yes, my invention is ready, but still I need some time to kind of finalize the invention, to create some data, to show some its applications. If you need some time to work out, then you can file provisional application. You get 12 months period to file complete specification from the date of the provisional application. Within these 12 months, complete your work and file complete specification. Company should ensure security of data software, sign agreement with employee regarding the inventions originating in the company. Yes, there can be issues regarding inventorship of the inventions, and I have seen many such issues and these issues finally go up to the court. So in the course of the employment, it is always advisable to have agreement in regard to the inventions generated during their duty to that company. So an agreement with employee regarding the inventions originating in the company. Non-disclosure agreement wherever invention disclosure is required before filing of patent application. So if you want to take some trials, or if you want to do some studies to check some parameters, then something like that, you might have to disclose your invention to the person. That time you please sign non-disclosure agreement so that your invention remains protected. And this non-disclosure agreement also helps in protecting claim of the other person over the invention. You might be knowing Bombay Chemicals company, Kasav Chap, that mosquito repellent coil. So they have one suit pending now. They have prepared a mosquito coil with peppers. The mosquito coil which we have seen is that green coil, which is kind of having hardness and it breaks. So they had come up with paper coil. It was a paper coil, unbreakable paper coil, and it can be hanged on the wall. So while when this invention was getting finalized, or when he was inventing this product, he had gone to paper manufacturer and had asked to manufacture the paper sheets the way he wanted, whatever layers, thickness, whatever. So he had given some specifications to the paper manufacturer and asked to manufacture this paper. He had done so, and in the course of interaction, even this paper manufacturer had given some suggestions. If you don't want to bend it, but if you want it in the want to be in the circular pattern, what can be done, and this and that. So their discussions were there, and even he had given some suggestions on how it should be. That paper manufacturer was knowing that he is going to file patent. He filed patent. Bombay Chemicals filed patent. He congratulated him. Patent got granted. This paper man, he kind of, as a courtesy, called paper manufacturer, said, "Oh, I got that patent, and I'm very happy on that." He congratulated him. And after he saw some success of that product in the market, he filed suit saying that even I am the inventor of the product. So to avoid such kind of situations, you have to file agreement while disclosing the invention. So no objection in law for R&D and experimental work using patented invention. If a patented invention is being used in laboratory for research work, there is no inhibition, or there is no objection in law for use for R&D. Only commercial use of the invention is not allowed. Conduct novelty and inventive step search before applying for patent. So before applying for patent, just check whether similar kind of patent has been filed anywhere in the world, whether any similar kind of publication is there, because patenting is a long process. After some 3 to 6 years, you will come to know, oh no, there are some citations or some publications which are documenting this invention. It's not fair. You have wasted your time, you have wasted your money. So just to avoid that, when you are about to file patent application, please check for the novelty search and patentability search and get assured that yes, this is patentable invention. Even then, there will be objections from patent office, there will be some queries from patent office, but at least from your side, you have to make sure that there is no similar invention which can form citation to the invention being filed for patent. What can be patented? Invention that is either a new product or a process involving an inventive step and capable of industrial application. So, invention has to be either a product or a process. Use is not considered as invention. I have seen many patent applications that claim use applications claim use as the invention. Use is not invention. The invention has to be some product, or it has to be a proper process with steps. Use cannot be invention. Patentability criteria in India. I think these criteria you all must be knowing. Novelty, inventive step, industrial application, and should not fall under the group of inventions that are not patentable. Novelty. An invention is considered to be novel when it has not been published in any of the prior art. So there should be no prior disclosure of the invention. If anything you do differently or distinctly than whatever is known in the prior art, even a little addition to it, then you will be able to satisfy the criteria of novelty. Satisfying criteria of novelty is much easier than satisfying the criteria of inventive step. Many of you might have filed patent applications and might have noted that when the examination report comes, novelty objections are very few. On very few inventions, novelty objections are there. However, on inventive step, nearly each and every patent application is objected for inventive step. So, we will take example of chair. Chair, it has 4 legs. If somebody fixes one more leg for the chair, 5th leg, okay, whether it is required, whether it has any utility, we'll keep it aside. Chair has 4 legs. Somebody has fixed one more leg. Now chair has 5 legs. It's new. It's novel. Novelty criteria satisfied. Okay, now going further, inventive step. Inventive step is a feature of an invention that involves technical advance as compared to existing knowledge or having economic significance, or both, making the invention non-obvious to a person skilled in the art. Inventive step is the thing which is critically difficult to satisfy. You have to show technical advance. Now I have fixed 5th leg for the chair, but what that 5th leg is doing, is it really required? Is it bringing any technical advancement? If you say that there is no technical advancement, it is of no use, then it is lack of inventive step. But if you can show that when a person sitting on the chair tilts on his sides, the chair does not tilt for more than say 20 degrees or 30 degrees, and there is less chance that person will fall from the chair. Yes, there is some application to what you have done. There is some technical advancement which wasn't thought by anybody earlier than yours. So when there is technical advancement, you are satisfying the inventive step. You have to show some structural features for the invention, and you have to show how these structural features are bringing technical advancement to the claimed invention. Industrial applicability. Capable of industrial application in relation to an invention means that the invention is capable of being made or used in an industry. Any invention for satisfying the criteria of patentability has to be industrially applicable. It should be capable of being made in industry or capable of being used in industry. I have refused one patent application on this basis. They had used human cornea as raw material for producing that XYZ product, what they had claimed in the patent application. Now, if they are using human cornea as raw material, how they are going to make it in industry? When you say industrial production of anything, you are making it at large scale and you need that much of raw material. From where they are going to procure that much of human cornea? So that invention was considered as non-patentable invention under this section. Non-patentable inventions, the products and processes which are not patentable are those which are not inventions as per Indian patent statute, and inventions related to atomic energy. Now, non-patentable inventions, This section 3 is very, very important section. An invention which is frivolous or which claims anything obvious contrary to well-established natural laws. Any machine functioning without any input and still giving output, impossible. So this kind of claims cannot be allowed. Somebody had come to us while I was in patent office. He had applied for patent, old man, and his invention was water which has a property of treating AIDS and cancer. So how this water was manufactured? He himself had come to see me, and he was telling that at 4 o'clock he has to get up. He keeps the bottle filled with water, and then from roof, some divine light comes through the roof, and there is some figure. That figure blesses that bottle containing water, and then the water turns magical and can treat AIDS and cancer. I have treated many such patients, and therefore patent should be granted. Patent is for scientific inventions. How one can grant patent for such kind of inventions? Further to this, for such kind of inventions, it is difficult to find document to cite any document. For regular inventions, yes, you can get citations, but for this kind of inventions, refusal is also very, very difficult, because for novelty objection, for inventive step objection, you have to cite some document that it is documented here, it is said here, it is disclosed here. But such kind of inventions, it's difficult to find documentation also, and it is difficult to fit in the criteria for refusing the patent application. So anyways, an invention, section 3B is an invention, the primary and intended use or commercial exploitation of which could be contrary to public order or morality, or which causes serious prejudice to human, animal or plant life or health, or to the environment. Any device or machine for theft, method for adulteration of food, these kind of inventions which are against public morality or public order are not patentable inventions. They are refused under section 3B. Now section 3C, the mere discovery of scientific principle or the formulation of an abstract theory or discovery of any living thing or non-living substances occurring in nature. So if anything which is already present in the nature, you are isolating it and you are claiming it as patentable subject matter, it is not allowed under section 3C, as it amounts to discovery and not invention. So mere discovery of scientific principle or the formulation or abstract theory is not patentable subject matter. A constituent present in plants. You can extract the plant material, you can isolate the substance from the plant material. You have done efforts, there are human efforts involved, but still then that isolated constituent is non-patentable subject matter. Why? Because it is already present in the nature. You haven't created that substance. You have isolated it, you have discovered it, you have found it out, but you haven't made it. So such kind of inventions are not allowed which are already present in the nature. Microorganisms. Microorganisms which are already present, but yes, you are discovering it, you are isolating it, you are purifying it, you are characterizing it, you are saying that yes, this is new microorganism and I have found it. You have discovered the microorganism, you haven't made it. So microorganisms which are naturally occurring, non-patentable subject matter. However, if you change the genome of the microorganism by say transformation, by say mutation, then the microorganism is changed. It is not naturally occurring microorganism, and such microorganism is patentable subject matter. Now, again section 3D, very important section for India. Many of the patent applications, of course it's in relation to pharma industry, have been refused under this section and are still being refused. If it's a known substance and if you produce any new form of that known substance which does not have therapeutic efficacy more than the parent compound, then that substance is not allowed. New form of the known substance is not allowed if it does not have improved therapeutic efficacy. There is famous case on this. Even some like this case, some of you might be knowing. It's Novartis case. Gleevec is the medicine. It was for leukemia, and the parent drug imitinib was known or was in the market since 1993. It was disclosed in 1993, and further to that, beta crystalline form of this imitinib was developed and was applied for patent. It was refused under this section, and Novartis went in appeal. Appeal was filed in 2006 for the order of the controller. In 2013, April 2013, I guess. Yes, in April 2013, this case was decided by Supreme Court, and the application was refused. This judgment of Supreme Court is 112 pages judgment, which goes into the history of the patent law, and it's very, very well written judgment. And this is a landmark case for section 3D. Again, because of this section, India is on the priority watch list of US Trade Organization. The US Trade Organization prepares the watch list of the countries where the enforcement of the intellectual property rights is bit issue. So India is making its position in that list because of this section. Now, a substance obtained by a mere admixture resulting only in the aggregation of the properties of the components thereof, or a process for producing such substance. Mere admixture of two or more substances is not considered as invention. There has to be some synergy between the mixture or between the components of the mixture, then only it is patentable subject matter. Some, like if the two components A plus B are giving same effect, what A is giving its own effect, B is giving its own effect. There is no additive effect, then it is not patentable subject matter. But what A alone cannot do and B alone cannot do is being done when A and B are coming together, then yes, it is patentable subject matter. Again, from engineering point of view, this section is very important. The mere arrangement or rearrangement or duplication of known devices, each functioning independently of one another in a known way. If the components of any machine are rearranged in such a way that the results obtained are similar to the previous arrangement, then it is no invention. Yes, there is novelty that it wasn't placed in the fashion you are placing it. Earlier it was placed differently, you are placing it distinctly than that, and therefore there is novelty involved. However, as it is not giving any result which is not known to the public or which was not earlier achieved, then this only rearrangement of the components is not patentable. If you can show that this rearrangement is resulting in some surprising effect or achieving some effect which wasn't achieved earlier, then yes, the rearrangement can be called as a patentable subject matter. There has to be some surprising effect. Method of agriculture, horticulture, not patentable. Yes, any method of direct treatment to human being. It can be prophylactic, it can be for treatment, it can be diagnostic, but any treatment to the human body or animal is not patentable subject matter. Plant or animal part, not patentable subject matter. Yes, section 3K, again very important. A mathematical or business method or a computer program per se or algorithms. So computer programs are considered to be non-patentable in India. Computer programs or software is protected by copyright. However, it is not being considered as patentable subject matter. If you want to convert it into invention, if a computer program you want it to be protected as invention, it has to be embedded in the hardware, it has to be protected along with the hardware. Computer program per se is not patentable subject matter, and it has to, some technical effect has to be attributed to that arrangement. Then only it is a patentable subject matter. This is again, this section is also in very much debate. Subsection L of section 3, literary, dramatic, musical, artistic work, these all are subject matter of copyright. A mere scheme or rule or method of performing mental art, act or method of playing game, again copyright, not patentable subject matter. Presentation of information, not patentable subject matter. Topography of integrated circuits, again copyright, patent cannot be granted. An invention which in effect is traditional knowledge, or which is an aggregation or duplication of known properties of traditionally known components or components. So traditional knowledge, not patentable subject matter. India has TKDL, Traditional Knowledge Digital Library. All the traditional knowledge is digitized and electronically available for reference, and therefore we can prevent granting patents to inventions dependent on the traditional knowledge. Inventions relating to atomic energy. Again, atomic energy inventions are not patentable subject matter. Whenever any application is received for the inventions related to atomic energy, it is directly it is sent by the patent office to Department of Atomic Energy. They evaluate the application, and if they say yes, you can proceed with this application, you can examine the application, then only the application is examined. Otherwise, the application is not examined, citing the Department of citing the this section of atomic energy, that invention relates to atomic energy and therefore cannot be processed. Now, publication versus patent. Our journal publications, so authorship somewhat negotiable, must have done the work, effort paramount. The inventors have to work on the project. Future ideas can interfere with subsequent patentability. In conclusion, we do write that, oh, this is possible, that is possible, further this should be taken up, this study should be carried out, and it may result into this. So these future projections can interfere with the patentability. If you really take up that project, if you work out, and if you really get those results, then these projections can interfere with the patentability. Only directly comparable results can lead to loss in priority. Now for patent, inventorship is a matter of law. Constructive reduction to practice encouraged, that is commercialization of the invention is encouraged. Conception paramount, whose idea, who has actually developed the invention, that is paramount while filing patent rather than actual work on it. Disclosure of ideas for as many future uses as possible strengthens the patent. Results from analogous systems can result in prior art and obviousness rejections. So if there are similar documents, it will be objected under inventive step. What are technical parts of a patent? Now we know that specification can be either provisional specification or complete specification. Provisional specification can be in a simpler form. It can be one-page disclosure of your invention, or it can be, as said here, into different sections. Even plain disclosure of a para or one-page disclosure is enough as provisional specification. However, when it comes to complete specification should have these elements. Field of invention, it should disclose what the invention is about. Invention relates to background of the invention. Background is the prior art or whatever is already existing in that field, what problem you have seen and how you are going to solve that problem, what will be your solution to that problem. That is the background of the invention. What do you know about that invention before you started your work? Summary of the invention. Summary of the invention is actually a summary of what your invention is, or actual invention has to be summarized in this para. Brief descriptions of drawings. If you are going to provide drawings along with the specification, you have to describe each of the drawing, and this para should be mentioning the description of the drawings. Next is detailed description. As I said, description has to be fully and completely disclosed in the specification. So this is the para for describing the invention. Full and complete disclosure of the invention is mandatory. Best method of performing invention should be mentioned. Generally, best method of performing invention is mentioned as examples. If some of you might have seen the patent applications or patent specifications rather, might have seen after this detailed description, there is a section of examples. So what are examples? Examples are actually the best method of performing the invention. Invention is being worked out for 5 years, 6 years, 7 years. It is not possible to document. Yeah.
Madam.
Yeah.
To interrupt you.
Yeah.
So, can we conclude in some time, because next session is scheduled at 3:30 sharp.
Okay, fine. Yeah. So detailed description should provide the examples and the best method of performing the invention. Claims is the actual part where you get legal protection. Legal protection is not for the disclosure in the description, but claims is the actual part where you get protection for. Later is the abstract and drawings. Drawings are to be provided separately. Now, as there is a request for concluding this section, we will just go through the slides. This is ordinary application is the application which we file in India. Convention PCT, I think like it needs a bit time to explain this. And patent of addition, that is improvement on the existing patent application. Divisional application, if by fluke you have claimed 2 inventions in a single application, one or application can be filed only for one invention. If 2 inventions are there in application, it can be divided out. How to obtain patent, and this is kind of how patent application flows in the patent office, that is publication, examination, then hearing and grant of patent. Then how you can enforce your patent. Patent enforcement tool is infringement, filing suit in the court. Then legal tools in regard to patent rights is one is pre-grant opposition, one is post-grant opposition. Pre-grant opposition when it is published before the examination, pre-grant opposition can be filed, and that is before the grant of application. Pre-grant opposition can be filed saying that this patent should not be granted as we know this invention beforehand. Post-grant opposition, once it is granted and then you come to know about it, then you can file post-grant opposition within 1 year from the date of publication of the granted patent. And thereafter, if you still want to oppose the patent, that is High Court is the boundary then. Technology transfer, you have to commercialize your invention. You can get royalties, it can form assets for merger acquisition, will help in developing technologies. The licensing can be exclusive, sole or non-exclusive licensing, then it is regarding infringement. So to conclude, what I'll say is intellectual property rights are very, very, very important rights for economic development of a country, and we have to kind of work on these in this intellectual property rights area. We have to invent, we have to create, we have to protect, and only protection is not enough. Only registering the rights is not enough, but we have to commercialize these rights, we have to enforce these rights, and these inventions or these products, GI products, should be taken to the market. Then only actual development of the country is possible, or then only we can get benefited from the inventions or our creations. The authorities through different legislations and through different policies should maintain some balance between the interest of the public and between these exclusive rights created, so that public or the common people of our country do not suffer with the exorbitant pricing, but still we respect the inventions and inventors get their own credit. So thank you. I think I have a request from Dr. Rane, so I respect his request. Any questions?
Thank you, Dr. Ujjawala Haldankar, madam. Am I audible? Loud and clear?
Yeah.
Yeah. So thank you, madam. Now this is the time for the question answer. We have a very short time already. It is 3:30 over. And I would like to have hardly 1 or 2 questions quickly. And if there are some more questions, then I request the participants to kindly take the things offline. Okay. So if there are questions, then please write those questions in the chat box, or you can ask the question directly. It was a wonderful session, madam.
Yeah.
On the behalf of the entire organizing committee, I give you our sincere thanks for sparing your precious time and igniting the minds, and also adding a great value in the context of intellectual property right. So this particular knowledge is really helpful for all of us in the journey of filing the patent and creating the IPR.
Ma'am, very good evening, ma'am. I would just like to ask one small question about the branding. I have a license software, and I used the template from that software, and I have modified that software. So is it in which category it will come included? Should I use this as my branding, or should I have to submit for the copyright?
Yes, it will be subject matter of copyright. It's actual software, right?
No. Means, for example, in the PPT, I have a license copy of the Microsoft Office, and I have modified that PPT template to the another thing. It is in another software as well. So should I use it as my branding, or I have to pay for the copyright?
You will have to pay for the copyright, as you are making commercial use and you are improving on that. Without use of their product, you won't be able to achieve your product, right?
Okay.
Yeah, so you will have to pay royalties to them.
Okay, fine.
Yeah.
No worries, ma'am. Thank you so much.
Okay. I think there are no more questions. So thank you very much. And now it is to the organizers.
Thank you, madam. It was a really wonderful session. And whatever the questions are there, if there are, those questions can be taken offline.
Sure.
Yeah.
I appreciate it.
Your email address is already shared with the participants. You have already shown in your PPT. So
right. Yeah.
Participants can connect with you through email. Fine.
Okay. Thank you. Thank you.
Bye-bye.
Bye.
Organizing team: Sadhvi, Kaif, Ritesh. Our second speaker, Mr. Surender sir. He is a coordinator at Western Region Office at AICTE for innovation at Institution Innovation Council. He is available. He is already in the meet, and I request our organizing team to kindly introduce him, welcome him, and then hand over the session to him for receiving the keynote address. Yeah. Organizing team, please start.
Good afternoon to one and all present here. I heartily welcome today's keynote speaker. It's a great pleasure for me to introduce you for this session, Mr. Surender Rammurthy sir, is our second speaker for today's session. Mr. Surender sir completed his bachelor degree in electrical and electronic engineering in the year 2014. After that, he completed his master's in power system from Anna University, Chennai in the year 2017. After that, he established his company named iRobo Innovations Private Limited in the year 2017. It's a robotics IoT-based company for automation in industry and home. Since he is fond of the electrical field and to get back to the core industry, Sir completed his power plant training from NPTI Faridabad in the year 2021. After working there for roughly an year, he got an opportunity to work in the Ministry of Education Innovation Cell as a startup fellow in 2022. Since then, he have handled the implementation of the National Innovation Startup Policy, IIC, WRO, and SCRO Zonal Coordinator, as well as the MBA in Innovation, Entrepreneurship, and Venture Development Program. Now, Sir is going to spark us on the topic Institution, Innovation, Framework, and Path Ahead. We are very happy, Sir, to have you a resource person for 5 days online faculty development program. Now, I would like to invite Mr. Surender Ramurthy, sir, to start the session and address our participants. Over to you, sir.
Okay, thanks for the introduction. It's a lovely introduction. Thanks for that, sir. Let me share the presentation first. I hope you can see the presentations, right? Can anyone confirm? So anyone can see the
yes, sir. Yes.
Visible, sir?
Yes, sir. It's visible, sir.
For this information. And I didn't prepare for a lengthy presentation. It's like a half-an-hour presentation only. So I will try to elaborate as soon as possible. And can the rest of the people can mute the mic? That will be helpful for me. Okay. And myself, Surender. I'm. Hello. Yes. Okay. I'm Surender. I'm handling the Institution Innovation Council for the WRO zone and the ACRO zone, that is from Maharashtra, Goa, and Andhra Pradesh and Telangana. These region I'm handling the Institution Innovation Council along with NISP and MBA in IEV and PGDM course. So right now, this is the status of our country right now, because in the year 2022, the Global Innovation Index, we are at the 40th position. And we have a great potential to get the higher ranking, but we are lacking in the certain key areas where innovations, technology transfer, IP related. In this area, we are lacking very much. If we have like 0.1, 0.2 scores extra, that would have impacted like 4 to 5 days again. So our aim for this year is to increase the ranking only. So right now in our country, there are 63,000 institutions, upon which 10,000 are technical and rest of them are non-technical in background. But most of the myth the non-technical institute is facing is like how they can contribute in technology aspects. But the thing is like they have more scope in the technology related aspects like arts and science. They are the major area where they can focus in patenting the to create the patent and the IP related informations. Okay. So in our national education policy also in the 2020, right now we are focusing on creating the innovation related and entrepreneurship related. That is our main focus for this policy. Okay. This status is showing off about the Global Innovation Index, and this there are total 84 parameters where the Global Innovation Index has been calculated, upon which the section 5.2 is specifically focused on innovation linkages only. So I have created a comparative analysis with respect to our country and to the top performers. So even the top performer, like overall percentage, like the first person, the first country who scored the first ranking, that is Switzerland. Even though they are in the first ranking, but they are having the 5th position in Global Innovation Index in the innovation linkage area, but the Israel having the first ranking because of the technology transfer and the patentable and commercialization aspect linkages. In this area, Israel has the upper hand. You can see like the financed by the abroad GDP. So here we are not having any such collaborations with any foreign companies where the technology which we have created, that a patent which we have created and has been transferred. Some Indians who have created the patents, but that patent has been filed in abroad, so that is not considered for our country's GII. So what we have to do is like the patent which is filed in Indian Patent Office, that have to be commercialized to a foreign, then only we will get the scores. So you can see like Israel got 2.6 that itself they are getting the first ranking. They are getting 0. So the second position, the third position, the point is 0.4 only. So if we focus here a little bit itself, that will impact immense in the global innovation index. Likewise, the Institution Innovation Council, this is coming under Ministry of Education Innovation Cell, in which there are a lot of initiatives we have created. One is IIC, National Innovation Startup Policy, like the School Innovation Council, IPR, Smart India Hackathons. These are all the initiatives of Ministry of Education Innovation Cell. So how we have prepared is like the program. First, there should be a start point, there should be an implementation section, there should be a output section. So we have split it into 3 sections. The input is of NISP, National Innovation Startup Policy. So by creating the policy, we should incorporate the innovations and everything, like how to do and everything, the set guidelines. Then it will be then we have to get into the implementation stage. The implementation will be done through the Institution Innovation Council. Then the output, whatever you have done so far, that will be displayed in the ARIA ranking, that is Atal ranking for institution on innovation achievements. So that ranking will show like how much you have processed in the innovation area or technology area in this aspect. So this is our process flow. So let me start with the first roadmap, that is our institution's innovation policy, National Innovation Startup Policy. What we have done is like we have created a set guideline framework where it consists of like if a student or a faculty who have created their own startup, or even though if they have an idea or innovation, a proof of concept, that can be nurtured, and how that should be nurtured, and how it should be pipelined, and how it should be converted into a startup, and if they are converted into a startup, how it should be commercialized, and what are the parts that the institute have to face, take a part in it, and if the faculty is working in the institute and they are part of a company, and what the institution can do and the faculty can do. These are the main aspects has been covered by this NISP policy. So the main thrust areas for the NISP policies are first is like for the governing pipelines, like creating a pipeline for the structures, like from ideation stage, and how to process to give information to the students, or conducting events and sessions, and how to mentor them and nurture them and convert into a patentable product, and converting that into a commercialization product, and how to nurture the startup. So that is the pipeline. Okay, then to nurture the startups, we have to take a look into the incubation and pre-incubation supports. That is the next aspect. And the other aspect is of IP guiding framework, like intellectual property. If the students and the faculty is creating their own startup, and what are the criteria that defines like it should be co-owned or it should be solely owned by the innovator or not. So that will be guided in that policy itself. And the next is like if the faculty or student having a startup, and what kind of equity share percentage can be adopted by the institute while they are studying or while they are working in their own institute. Like that set criteria has been discussed in that area also. And the faculties who is having the entrepreneurship, and they are receiving the full salary, and they are working the full load and everything. Likewise also we have descriptions and resource mobilization and incubation supports and everything. So these are the trust areas we have looked into it. So upon which there are 2 to 3 main points where it stands alone compared to the other innovation and startup policies. Actually, this is like a guiding framework. It is not an actual policy. With this guiding framework, each institute have to create their own institution policy by which you can address the constraints which you are facing specific for your institute and the university. For example, the institute A is like we are considering 2 universities. The university A might have a different policy rules and B have a different policy rules, and your institute may be affiliated to another university, and you have to obey to that affiliating university's rules and everything. Okay, for that only we have created a guideline framework so that you can adopt whatever the information you can require from this policy, and you can create your own institution policy. So in that aspect, you have to create what we are focusing is like highlights is the institute should allocate 1% of the annual budget so that they can spend it on innovation and entrepreneurship related activity, creating the IP patent fees. They can bear it likewise, and they can conduct some competitions, the prize monies and the seed fund. Those things also comes under this budget only. The next will be of academic breaks, the semester breaks, if the students can take if they are working in the startup, and they can continue their studies after taking the break also. And there will be some concessions the students can avail if they are working in a startup and they are continuing the study also. Like for example, the universities generalized standard is like they should have at least 75% of their attendance should be there to attend their end semester exams. So to weigh off it, they can like they can adopt for this policy where we can given some waiver, and that percentage whichever is lagging, that can be assessed by the committee members where the work has been done by the student during that period or not. So by which the way off can be done. Likewise for the faculties who is having their startup and who is working in the full time also, they can avail for a sabbatical leave, or they can have a workload reduction or the salary reductions, or if the student faculty is working full time and receiving the full salary and also working on their startup side by side, if it is above their 20% of office time they are spending on it, means they should pay some equity to the institute, and the equity percentage how much it should be, like that. Then the major set aside point is like this is the major point where the this policy standouts is like we have fixed the equity share percentage. Generally the universities or the institutions will say like they are having an incubation centers, and if you are having a startup and you are trying to incubate in, as a part of it, they may ask like 20% of the equity share you have to provide to incubate in their facilities and to avail these kind of facilities. That is scrutinized, and we have generalized into like 2 to 9.5% only the institute can hold, and that too if the institute have a Section 8 company or a special purpose vehicle. So the institute can't hold the equity share from any startup or any persons directly under the institute name. The institute should form a Section 8 company by which the equity should be holded, and that equity should be whatever the amount they are receiving now, that should be utilized for this innovation and entrepreneurship related activities only, rather than the fundraising of their own institute. Okay, there are bylaws within this aspect also. So this policy cover these aspects in this shape, in this way. Likewise for IPR and ownership also, if the student or faculty with developed an idea which is patentable and they are applying for a patent, the institute can't take a part if the IP is being generated without utilizing any facilities of the institutions. Okay, then only the idea will be solely owned by the innovator. If in the other case, if the innovator utilizes some facilities or a technology or another help from the institution, then the patent should be co-owned by the institute and the innovator. Likewise. So this is the status of NISP. Right now, around 3,000 plus institutes have been joined this NISP campaign, upon which 800 institutes have formulated their own policy, and around 600 institutes have implemented a day-to-day basis, and more than 1,000 or 2,000 startups, as of our count, it may be more than that, has been benefited, and it is under the students or faculty, maybe they have some leaves and they have utilized these facilities accordingly. So I am requesting all the institutions to take a look into it and formulate their own policies. So this is the entry point of the MIC. Okay, you have created the policy. So what you have to do? Then you have to implement, like you have created a backbone structure, and how you're going to implement that will be done through the Institutions Innovation Council. So this is the state-wise distribution of adoption status. That will be. Let's come to the Institutions Innovation Council. So this is where most of the institute will have their activities, competitions, everything will be conducted under this aspect. Okay. Right now, Institution Innovation Council have more than 6,600. This is old data, but as of today, 6,600 institute have joined the IIC. And this is the growth, of course. And one of the major, like WRO has the largest number of Institution Innovation Council across India. Right now, it's 1,100 institutes have joined in Maharashtra alone. Likewise, in other zones also, it's mentioned accordingly. This is the distribution of type of universities and institutions, how many have joined and everything, apart with respect to the zones. I think this session is telecasted to the WRO, that Maharashtra region, so that will be coming under the WRO zone. You can see the status of your institutions. Okay. So now comes the major area for the Institution Innovation Council. The councils, in that we have asked the institute to conduct some activities for the students or the faculties in these 4 aspects only. We have distributed the academic calendar into 4 groups, like Q1, Q2, Q3, and Q4. The first quarter will be mainly focused on inspiration, motivation, and ideation area. So in that, what we will ask the institutes to do is, like, they have to conduct some activities related to basic innovations, like aspects like how to be an entrepreneur, creating entrepreneurial mindsets, and how to create an idea, create critical thinking, design thinking. That will be happened in the first quarter. So then next, the set of students who is moving to the next quarter, they should be focused on validation and concept development, where the initial critical thinking that will guide the students or the faculties to convert that idea into a POC, proof of concept, and they can develop their ideas into that. For that, the institute have to conduct the activities related to, again, the critical thinking, design thinking will be there up to the end of the thing, end of your prototype development. Then the institute have to conduct some activities related to develop their idea, like AI/ML, how they can incorporate that AI/ML into developing into a product, and how to generate it into IP, awareness of IP. Then the third quarter will be like prototype designing, competitions related to things, and business model development. And after the third quarter, then how to create a startup and what are the difficulties they will face, like real-time examples and support systems. So in this aspect only IIC is focusing on. Now, as per recent status, right now 51,000 faculties are under IIC institutions, 72,000 student members are there, likewise, in which the Innovation Ambassador Training Program, it's a new concept, like we have incorporated 2 years back itself, 2-3 years back. This training program will convert the faculty members into trained experts. So down the year, when in the IIC versions, like IIC 1 to 4, we faced, most of the institute faced the issues like they need experts to conduct some sessions in the specific area. So, and most of the experts are asking some remuneration amounts to take such sessions. So most of the rural area institutes are facing some difficulties in that. So what we have done is, like, we have created one training program. It is called as Innovation Ambassador Training Program, through which the faculties of that institute can go through 13 aspects of training fields, in which they can get specialized through attending the online pre-recorded sessions and giving some assessments. Likewise, if they can be a basic trainer, after that completing the basic stage, they will convert into an advanced level trainer, and they have to go for another set of sessions. After that, those trainers will be having an aspect like they can conduct sessions in their institute, and also along that external institutes apart from their institute like that. And those innovation ambassadors will act as mentors for to convert from idea stage to the innovation, and innovation to the startup stage. So in this aspect, the innovation ambassador training program has been mapped, and right now 18,000 plus innovation ambassadors has been trained in our wing. Okay, right now the IIC is in this 5th version, like 5th year we are writing right now. So till now it was like a centralized approach, like the only one location, like all the coordinators will be controlling all the institutes, like what they have to do, the verification and hand holding and everything. So to decentralize it, we have created a zone wise approach that we have split it into 9 zones. And that 9 zone has been split into 31 sub zones. That is, we are calling it as consortiums. Okay, I will come to the slides after that. Okay, through consortiums, the institutes and the faculties and the students can get the mentorship from the well-performing institute. Like each zone will have around 15 to 20 well-performing institutions, and they will act as the governing members, so that the institute can get some basic supports, like how to do the programs, how to mentor the students, and if they are lacking in any resources, those members who is in the governing members that can reach out to you, and they can and the other institutes can utilize some resources of the institutions, and they can reach out program for incubation facilities likewise. So these kind of ecosystem we are planning for this year. It is conceptualized, and we are just right now implementing it. This is the pilot year. And based on the review of this year, we will incorporate it for all over India. Okay. So apart from these kind of collaboration and handholding, that is only for basically for institution related. So here for students, what they can benefit from IIC. So mostly they will see in this aspect, like what we can get it from IIC if we are joining in the course and everything. So in IIC, we are having IPR Innovation Contest and Innovation Repository. Innovation Repository is mainly focused for the institutions, but we have challenges for the students, like where the students can submit their ideas or innovations or the startup related informations in the IPR portal, and that will be verified by your institute, like that idea or innovation is eligible for further process, or they have any fruitful idea and that is not being copied from any other resources like that. And once that has been done, they can be mentored, and they can convert from stage A to stage B, like ideation stage to the innovation stage, and likewise for innovation to the startup. Okay, in this area, the students can get funding also. That is one aspect where we the funding support and the mentoring support can be given and will be guided through other persons, rather than the innovation ambassador, that is of faculties who have undergone our training program as well as other programs and others. The other is like we are incorporating state and central agencies, ecosystem enablers and incubation centers in this area, where the innovations and the ideas can be posted by the students to those respective agencies, and where they can scrutinize and they can incorporate, or they can incubate it in those areas. And sometimes it will be leading for funding and the further development stages also. So that is where the students will get in. Right now we have announced IPR Innovation Challenge, and that challenge will be the last date of the deadline for this challenge's submission is April 15th. So right now we are asking the institute to nominate the students or innovators, innovations which are having TRL level 4 and above. So actually TRL level is technology readiness level. I hope you all know about that differentiation, like what is TRL 1 and 2. Likewise, if you don't have the idea in that, and I will try to post one link, you can refer that one also, because that will take a lot of time to explain right now. Okay, so we are calling for TRL level 4 and above type of innovations. That minimum 10 innovations can be nominated by each institution, and that will be verified by us, and it will be further processed, and the last set of people will get some funding from us to convert that innovation or proof of concept into a startup or commercializable product. So right now, from the previous year, right now we have 75 innovations that has been funded and has been converted into startup, and they are in the stage of deploying and commercializing the product, because another 4 months are there get with them, and within that time period they will convert that idea into a commercial level product. Okay, so this is the aspects for the students, and apart from it, the institute will also get like the ranking. The main outcome for the institution will be the ranking and the recognition of the from the students and the innovation repository. Okay, the institutions will maintain this innovation repository, from which the institution can be judged based on the innovation generated and the idea generated, supported and mentored. So why we are collecting this kind of information, most of the institute will peculiarly ask. In the previous slide, I have mentioned, like in Global Innovation Index, there is an aspect for how much innovations or ideas has been generated and how much has been patented, and likewise. So in that aspects, right now we have developed these resources now. From previous year we have started. That itself impacted a lot in developing our Global Innovation Index. Okay, so whenever you are searching for innovations related information, the top priority will come for IIC and the NISP. Likewise, our Ministry of Education's Innovation Cell programs contributed an immense lot of impact in the increasing the ranking in the global level. So that's why we are collecting this information. Okay, so another one basic doubt the students is raising for submitting their idea in the IPR portal. In the previous lecture, the session is for IPR related, I hope so. In that, madam might have mentioned like the idea, whenever you are applying for a patent, that patent will be verified by the patent office, like that idea has been published anywhere in their any other portal, everywhere they will search for it. If there is any replication of that idea or innovation, then the patent will be denied for sure. Okay, the major misconception in IPR innovation repository is like we are also government agency only. We are not going to leak your idea anywhere. We are collecting this idea so that we can convert that idea into an innovation. That idea will not be leaked anywhere in the website. This is a secured platform only. So whenever the patent office searching, this search will not be impacted anywhere. Okay, sorry, I had to take one urgent break because one urgent call is coming. So sorry for the break. Okay, one more.
Surender sir. Hello. Surender sir.
Surender sir, you are not audible.
Surender sir. Hello. Surender sir. Dear participants, there is a small break because Surender sir received one urgent call in office. So he's engaged with that and he requested for the 5 minutes break. So right from 1:45 we are continued. So we can take a small bio break for 5 minutes and again we can join. You can continue to joining meeting. Okay. Surender sir will be continuing his session after 5 minutes.
Hello. Hello. Santosh sir.
Yes, sir. Yes, sir.
Sorry for the interruption. So actually, for TTO office proposal, they
I can understand, sir. I can understand.
Yeah,
There
I can't
are
able to avoid that
some
one.
of the urgent issues to be addressed at the administration level. Yeah. Yes, sir.
Okay.
Yeah, please go
Shall I
ahead.
continue?
Yeah. Please continue. Please continue.
Okay. Really sorry for the interruption. Okay. You can see the slides, right? Hello. Hello. Can anyone confirm?
Yes, sir.
Yes, sir. Thank you. Okay, where I was. Okay, I think I stopped at the state level consortium related information, and this slide is showing about the innovation ambassador distribution, like which zone have more number of innovation ambassadors trained. And as of now, like in Maharashtra, 1,500 innovation ambassadors are there. They are eligible to conduct some sessions related to IPR, policy creations, incubation facilities. Likewise, there are some 13 topics. In that aspect, they are eligible. Likewise, for each and every state, this number of innovation ambassadors are trained by us. Right now, we came for IPR Innovation Repository. I have previously explained you why we are creating that innovation repository. With that repository only, we can show to the global standard, like we have this much of ideas, and that much ideas has been converted into another set of innovation or a proof of concept, and that has been converted into startups. And from that innovation ideas numbers, how much has been converted into patent level stage, and how much patent has been converted into TTO, technology transferred and commercialized. So for those kind of information, we need a basic set of data and a centralized approach. So for that aspect only, we have created the IPR Innovation Repository. Not only that will stored as a data, we are planning to convert that into innovation and startup, as I said before, through that mentoring support and incubation support and incorporating agencies and to create funding supports and everything. The ministry from our end, MOE side, we are creating these kind of challenges, innovation challenge, through which we are trying to provide some fundings to the students who are all selected for the final stage. So likewise, we are creating another portal for the agencies like state government, central government, and private agencies, incubator, venture capitalists, and other agencies, TTO office and everything. They also can create some challenges, and they also can post some requests like these kind of ideas from this area, like IoT based. Likewise, they can request, and the students who already submitted their ideas, now they can post for that competition and their request, and they can be further processed by those agencies, and they can be incorporated by them. So that is one set of scope. So in this aspect only, we have created this challenges. Okay. Okay. This slide explains like how the institutions level at MSc level, how we are creating this challenge. Institutions for this IPR Innovation Challenge, the institutions should collect their innovations which are TRL level 4 and above, and they the institute faculties they have to assign some verifiers. Those verifiers to have to evaluate those ideas, and which are all got recommended, they are eligible for nominating to attend this challenge. Then the institute will nominate 10 selected innovation from each institute for this challenge. Then what we'll do, like we will scrutiny further, like from April 15th is the last date. After that, we will have a panel to scrutinize it, and from that, who are all got selected, they will go for a mentoring session, and who are all converted into in the mentoring session, they have to convert their innovation into proof of concept, and what all the conversion has been done, they will be again evaluated and mentored and trained, and that will be go for the final set of evaluation, where there is a scope of scalability and commercialization aspects. Those will be funded for the further creation, and they will have a 1 year time span where they have to convert their idea proof of concept into a commercial like a saleable material. So this is the concept for innovation challenge. So here the IPT innovation repository, how we have split it into like students based one in repositories there, institution side one is there, ecosystem enablers, that is the agencies side one login is there, and the innovation ambassadors. Those are all intertwined in each and every steps. So that relation has been mentioned in the slides. So actually here right now, till now we have spoke about the institution level, like higher education related information only. So we have to start beyond that, before that, okay? So that's why we have incorporated the School Innovation Council. Okay, in that some schools, it's already been sponsored, and some labs has been created by Atal Innovation Mission, DTIO. Those are like Atal Tinkering Labs that has been already sponsored, and the lab facilities has already been created. So those labs will be utilized. Some schools are not utilized perfectly. So what we have done is like through this Institution Innovation Council, IIC, they can adopt maximum three schools under their wing. Those three schools will be mentored, and those lab facilities will be utilized by the school students, and we will expect the students to create some innovations or idea from that stage itself, because most of the innovations and ideas has been generated from the early age, from the age of 15 to 25. The most idea generated cluster is being in that area only. So we have to train the school students at that stage itself. So because students will always have a way of thinking in a different angle. Whenever the teacher is training in one aspect, but the students will always try to remember and learn and understand in a different aspect. So that will lead to the innovation part. So it's not like a bad way to think in another aspect also. Okay, so till now we have seen about the innovation, like how the policy has been created, how it has been implemented, and we have to see how the outcome is being generated, right? The outcome will be evaluated in these 7 key aspects only. Right now it is 9, but it is being compressed into 7 aspects. Sorry for the old information. So what we the 7 major information is like, one is like entrepreneurial mindset development kind of programs. So kind of IIC, like MOC initiatives, Kapila programs, likewise. Kapila is like a patent, like if you're having an idea and it is having a potential of a patent, and if you are going to apply for a patent cost is too much high. So to give some way of, you can apply for that Kapila program, through which the patent amount will be almost 80 to 90% of the payment amount will be reduced to support these young initiatives. So you can utilize that scheme also. That will be processed through the institutions only. So ask your institute to create a login in Kapila also. Okay, that initiatives will be ranked in that aspect, and the IND related infrastructures. If your institute is offering any innovation and entrepreneurship related credit or non-credit courses, that will also impact in the ranking. And infrastructures like pre-incubation center, incubation centers, technology transfer office, and how many have been fruitful, benefited from those centers. Those will also be evaluated. Then the innovations developed and startups established. These 2 main area is where the Global Innovation Index is taking a look into it. These 2 area, by how many numbers of innovation has been submitted by the students, and the startup has been converted from that. So that conversion rate will be considered in the 5th parameter of the Global Innovation Index. Okay. Then the next key aspect is for collaborations and investments. Like if you have any MOUs with the state and central agencies or industries, that MOUs will create extra impact in your ranking. The final is of IP related commercialization. This is also another important aspects, like how many patents has been filed, published and granted, and upon which how many has been technologically transferred to the industry for commercial purposes. So these are the areas where the ATEL ranking will mainly focus for the evaluation purpose. Okay, so I think these are the overall concepts of Institution Innovation Council and their initiatives and the further again. Okay. I really sorry, actually around 4:30 I have to go for another meeting, so that's why I'm winding it up. Really sorry. I think I have covered the major concept in IIC and everything. So if you have any doubts, you can ask right now. Hello. I think I can leave the session right now. I think so. Is anyone from the organization team can acknowledge it? Yeah, okay. I think I can leave the session right now. So if you have any questions related to this Innovation Council and how to apply for this challenge and everything, you can post us a mail. I will share my mail ID in the chat.
Okay, sir. Thank you very much.
Okay, thank you so much.
Am I audible? Hello. Hello.
Yes, sir.
Yes, sir. Thank you.
Yes, sir, you're audible.
Yeah. Surender, sir. Surender, sir. Hello.
I think he has left, sir.
I think he has left. There was some issues at the YouTube streaming, so I was busy with that. Okay, fine. I thank all the participants to attend the session and making this entire program as a successful event. So dear participants, the feedback link is important. I request all the participants to kindly fill up the feedback for the each session that is going to be considered as the attendance, and hence your feedback is important for us. And attendance is linked with the certificate. And hence we request you to kindly fill up the feedback for the each session. Okay.
Okay, thank you, sir.
Yeah, and many participants are asking for the PowerPoint presentation. So whenever these respective speakers will be sharing their PowerPoint presentation, we will collect all these PowerPoint presentation, and in one go we will be sharing with all the participants. Okay.
Yeah, it will be fine, sir. Good.
Yeah.
Okay. Sir, we did not receive the link for second session.
I shall once again I shall ask the organizing team to upload it on the chat. Okay.
Okay, sir. Thank you.
Yeah. Yeah. सर फीडबॅक लिंक चॅट बॉक्स मध्ये टाका. हा हा.
Ma'am, link is shared on chat box. Please check.
Yes, sir, we received. Thank you, sir. Should we leave the session? Hello.
Mail केला का?
Shared, sir.
Hello, sir. Should we leave?
Yes, yes. Today's
Thank
work
you,
is
sir. Received feedback link. Thank you.
Yes, yes, yes. Thank you.
Koणाचं चालू आहे? इको. इको.
Yes, yes. Yes, yes. Thank you. 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 Thank you.
Dear participant, I would like to inform you that today's second session is over now. And dear participants, tomorrow's first session will start at 10:30 a.m. with more enthusiasm. Link will be shared on group. Join the session 10 minutes before. The tomorrow's morning session will be taken by Mr. Tapan Brahma sir. Thank you. Thank you very much.
Thank you, sir. Dr. Shrikant.
Yes, sir. Thank you.
Please give the message on YouTube also.
Yes, sir.
Please write.